Bill and Katie and Jay have done a really nice job to put you into the nitty-gritty of how to get the filings done and how to approach that information. And I'm going to ask everybody to take one step back from that, because I'll be looking at a broader goal that we've talked a lot about with Whatcom Ag Water Board and folks that are farming in the basin. As was said before, my role is to talk a little bit about what a water rights settlement might look like and how those are used, where they're happening, where they have happened, and what they may promise for the future. So with that, I'll hopefully start the next one. So again, there's an inventory that comes out of an adjudication. That's what it's about. It's about making a list of who has what water rights and what kind of priority they are. And it's to inform administrative agencies about who's got senior rights and who's got junior rights. So if there's a shortage period, they can turn off more junior water rights in favor of senior water rights. That's the prior appropriation doctrine that's in place in Washington and throughout most of the West. That's what the case is really about. So over time, Indian water rights for Native American tribes were not included in the permitting processes throughout our western states. And there was a case out of Montana in 1908 that indicated that federal water rights exist for tribes. And they include past, present, and future uses. They also don't get lost by not using water rights. So they're different than state water rights in that way. They're governed by federal law, and the United States government actually owns those water rights in trust for the tribes. So those are different concepts than water rights management in states over time. And so these cases started to happen in various western states to try to adjudicate those really senior water right claims, because tribes have been here. Often they make claims for time immemorial, and how they fit into the system of managing water in the state that already exists, and how they fit in to economies that rely on water and already are existing, and people who own property and their businesses rely on those water rights to make them successful. So in this basin, of course, you all know this better than I, there's an upstream tribe, the Nooksack tribe, that will have water rights claims, and a downstream tribe at the mouth of the river, the Lummi tribe. And those federal water rights that they will claim legally are based on the purpose of the federal reservation. So in the treaty that established the water right, that treaty will have a purpose that a court will look at to establish the implied amount of water. And one of the places we would expect to see claims would be for water that supports fish habitat throughout the basin. And this is a list of some other cases that have started to look at fishing water rights in the Pacific Northwest over time to really formulate a way for tribes to move forward and make claims for water in a basin that's not just on the reservation, but in the system. However, those are specific water rights cases for specific facts. And as we move forward in this adjudication, a lot of those legal claims are imperfect. The facts are different for different tribes. The facts are different across different basins. What's been happening in many western states and places where I work frequently are that communities come together with leadership for different users, so agricultural users and tribal users and the state and municipalities and utilities will come together and decide they, instead of doing this adjudication where everybody's in a courtroom and you might be objecting to your neighbor's use and you have this kind of litigious approach, that instead you look for ways to create what we call Indian water rights settlements. The Secretary of Interior has an office that's existed now since the 1990s called the Secretary of Indian Water Rights Office, and they help to support tribal claims, but also to support ways to resolve the interests of parties involved versus just creating a list by which you can pit water uses against each other. In these days where hydrology and climate seems to be making for very hot summers and real flashy storms, maybe a little bit like the rain I heard was here last weekend, the kind of hydrology is happening faster than the law can keep up with it. So again, these settlements are an alternative path to try to find money and solutions for basins to help settle Indian water rights claims and remove the threat of those claims displacing other water users in the basin. And again, I just want to be I want to be clear, but the law is not so clear. And so the claims that can be made by tribes, like the claims of different water users in agriculture and other places, are not perfect. And so in that circumstance, there's some uncertainty for everybody in their claims. So it makes a fertile ground for a settlement negotiation where communities can come together and create their own vision of how to go forward versus having the court making lots and lots of incremental decisions that make it difficult to implement projects to improve water resources. So in Indian water rights settlements, where I work a lot is in mediation between parties who are ready to sit down at a table and try to work through an Indian water rights settlement. For example, I've worked in New Mexico the last few years and have 2 settlements in 2 different basins that are moving forward for congressional authorization. Those settlements are looking to bring in about $900 million into the Rio San Jose Basin in New Mexico, which is this really small communities, towns of 10,000 people or less, and small Indian pueblos. And it's to help bring resources to increase water supplies to the area. In that particular area in the Rio San Jose, there was significant uranium mining there, and parties were unable to get clean water anywhere. And there's 3 tribes involved with it, the 2 pueblos and the Navajo Nation, and some of the water supply is just brown water that comes from their wells, and also a lot of the groundwater is used to keep uranium contaminated water from coming to the surface. So they really have real water supply issues there, and the settlement has provided dollars to create a better supply that's outside of those areas that can be brought to the area without changing or reducing any of the agricultural water uses. And in fact, then it has brought money to improve agricultural systems so that better water supplies can be provided in agricultural communities. But it isn't, all the parties have to want to come to the table to have that kind of discussion. So that's what the Ag Water Board is tasking us with, trying to get to the table to have sort of more of a win-win solution. Usually, the way you first get to the table in a settlement is by finding some places where you have shared interest. I mean, the tribes are looking for interest in water certainty, improving habitat for fish, looking at flows that may help fish. Agriculture is looking for certainty. You want to make sure that when it gets hot in July and you need water, you want to be able to turn on and not have any threat of interrupted supply, right? and people are looking for accountability with each other. Good in-stream flows are great, so long as you're not taking it out of my hide, right? So we want to find a place to look at how to create more resource availability for folks. And you have a lot of water up here. I mean, it's different than New Mexico or Palm Springs where I've been working. So there should be ways to look at technical solutions that engineering firms can help devise to move towards settlement ideas. I think one of the primary things I want to talk about today is how the agricultural community can approach settlement concepts. A lot of times in these settlements, when people want to start talking, they say, here are my key requirements for making a broad settlement type of work. And I've seen in negotiations over the 4 Klamath dams, when those dams were coming out, PacifiCorp took a position of, okay, we can work on removing these dams so long as we don't have to pay for it, we don't have liability for it. And if we can have those things happen, we can work together with folks who want to have the dams removed. And so agriculture was like, if we're going to have this happen, there's certain protections we want to. And so one of those key protections is having a protection from senior priority calls. Again, back to the prior appropriation doctrine, the most senior water rights usually get their water first. And if there's a big chunk of water occupied by tribal claims, for in-stream flows, for example, it could shut off junior water right users. And right now it doesn't do that because it's a 1985 water right. But if it was much more senior in time, it could do that. So in any negotiated deal, I think that a primary place to be is looking for a protection from priority calls. And that is a very, let me get to this part so I can go a little quicker tonight. But that's a place where settlement can make that happen rather than litigation. Litigation, you have narrow court decisions, you don't have funding to help those kinds of things. There's other litigation that occur. Tribal claims can be limited. The community's in an adversarial setting. Versus a settlement, there's a place to quantify tribal rights, a place to find money and funding for infrastructure development and economic development on tribes, but also remove threats to administration of agricultural water rights. That is a main concern as you add Federal Reserve tribal rights. In a lot of Indian water rights settlements, there are protections for non-Indians in those settlements. So in 2007, there was already a settlement for groundwater uses. It's a very limited area on the Lummi Nation. And in that settlement, the court ordered the final settlement and resolved the litigation. And in that settlement, the court said, the parties have agreed to depart from prior appropriation and have agreed that the tribe will not make a senior call against junior water users in this part of their adjudication. And that's happened in other cases as well. In New Mexico, the same thing. There was a case that Ammit from 2012 was the longest running water adjudication in US history in New Mexico, filed in 1966 and ran it did never finish. Instead, they finally moved into a settlement posture, and within, I think it was a 4-year period, they had a settlement in place to determine water rights and bring hundreds of millions of dollars into the basin to help provide water supply for tribes and protect water supply from irrigators. And that settlement, the same thing happened. The parties agreed that tribal water rights would not make priority calls against any junior water right holders. Two more settlements that I've worked on much more recently in the Rio San Jose and the Rio Chama have that same language in the settlement agreement that the parties have agreed upon. These settlement agreements are quite complex and take time to get to the negotiations, but in that bottom line kind of negotiating posture, it's a protection for people in agriculture who are using water rights to not be injured as part of the process. And then the settlements go forward to the court saying, we've settled our differences, Your Honor. We don't have to litigate about them. And the federal government, Congress approves these settlements. And the reason the tribe is willing to give up its ability to call out junior water rights is because the government is willing to bring money to the table to really help expand the pie. But it really takes a settlement, takes involvement by all the parties available. In other words, if you want almost $1 billion to do some habitat restoration and in-stream flow protection and storage areas, it needs everybody to sign off and say yes to that. So it can't be done without agricultural interest at the table. Same thing has happened in Arizona's settlement from 2004 and 2005. The tribes in Montana are reaching settlements. In the water court system there, I've heard their water court judges over time say the settlements are one of the best things that can happen out of this process because they bring so many resources for all the parties in our communities. So they're a good way to move forward with water rights management that doesn't prioritize one party over another. In fact, the settlements that, as they started to be used, the United States developed something called the Criteria and Procedures for Settlements, Indian water rights settlements. And in 1990, that was a while ago. I don't even think I was practicing law then. It was a while ago. And Indian water rights, this is official U.S. policy from the George Bush I administration. Indian water rights should be resolved through negotiated settlements rather than litigation. Similarly, there's a group called the Western States Water Council that all Western States governors are members of, and they revolve in the leadership there. And Washington, the state of Washington is a member, and they have adopted a policy of encouraging negotiated settlements and support for the federal government providing significant funding to resolve these issues rather than be litigating them in adjudications. Often as these settlements, if they can get up and running, the parties go to the court and ask the court for a stay of the litigation. So the red light, green light thing that Bill was talking about gets to be a red light on sort of defending all your claims and is a green light about talking about how to manage water resources. The good news is they're good for water basins. The news, I have to say, I can't say it's an extremely fast process. They take time to get moving. The Ag Water Board brought us in to try to help discussions. It's been very frustrating for everybody trying to figure out how to get those kinds of settlement discussions going. Tribes have been really insistent that they want the litigation to be in place before they begin discussions, so that those kind of issues are real. They take time, these big settlements, but they do happen. And there's 38 that have been approved since 1978. There's 12 sitting before Congress right now, looking for a total of, I believe, $12 billion. So there's a lot of money through programs to try to help with water management through these Indian water rights settlements. Again, sometimes litigation spurs the settlements, but a lot of settlements have occurred without some without any litigation, some without very much litigation. Sometimes a case gets filed and people are able to move into settlement postures almost right away. The U.S. Department of Interior is very involved. Settlements really vary. In this basin, there's so much what I would call decentralized water use. It's not like you have an irrigation company that opens a head gate at the top and delivers it all the way down and there's one party. Everybody has their own wells and uses, and so it's different that way. And we're trying out different kinds of approaches for creating kind of an umbrella plan that could work for agriculture in some kind of settlement proceeding. Usually when you have a settlement, there's an effort for everybody to go to Congress and get approval of a settlement act. And it actually is a place where, remarkably, Congress can be effective and bipartisan. And I know that sounds crazy because it's election time of year, but Indian water rights settlements pass in Republican administrations and Democratic administrations. In the most recent one out of Montana, the Trump administration passed the legislation. The Biden administration got all the signatures to make the agreement go forward. Afterwards, there are often Republican and Democratic senators working together to put legislation forward. So if you can do a settlement process, it's a place where Congress can find some success, which, in my opinion, is something we could use more of. So, again, benefits, they can be really wet water benefits to tribes. Litigation provides paper water that's hard to do anything with. There can be win-win protections for non-Indian users in settlements. And I think, as importantly, it's solutions that people develop who really know the basin. And in my experience, agricultural users really know the basin and the water systems more than anybody because you were out there on the ground all the time. So your contribution to how settlements look is really important. There's also the benefits of providing certainty, dealing with climate challenges. If we have bigger rainstorms that happen in a flashy way and then drier, hotter periods in the summer, it makes some sense to think about how to store. I was talking to Marty Mayfield earlier and Marty Mayberry earlier on how to, could we store some water that's, when you have a whole bunch of it coming for a period of time that you may use it later when it's drier. The other part of a settlement really is consistent with the responsibilities of the federal government. I think one of the biggest pieces I hope we can move toward in the next year while these forms are getting filled out and things are getting started is to find a champion. And when I say that, sometimes it's a politician, sometimes it's somebody at the county or a state level, sometimes it's somebody who can bring a group together. Some of the settlements I'm involved in, the parties decide to hire a facilitator, and that's one of the jobs I do as a facilitator and mediator, is I say, okay, we're gonna start meeting, and we're gonna start talking about what we wanna put together. And I make them, it's squishy, and people don't always wanna talk, but I make them get together every month and then every couple of weeks. And pretty soon we have a written document, and then we have to get together a little more on that. And pretty soon the lawyers are helping to write the document. And pretty soon people are saying, I don't like the way that's written, but I like this. And instead of sort of posturing about all of our positions, you get to a place. I was at a settlement on Monday in Palm Springs, and parties, they don't agree on everything, but they agree they're gonna get this thing done. And that they're gonna get some money and some new resources out of it and not be fighting in a lawsuit anymore. And so that's kind of the space to move to in an Indian water rights settlement. And it's really great also because people feel like they've really done something meaningful for their community for long-term periods. It does take investment of time, money, communication, and again, leadership. I think one of the key places is trying to find someone who would take this on and try to have people meet and try to bring the tribe together with ag users and other water users. The federal government does have a process for Indian water rights, a procedure, and the federal government is always in these processes. They have this phase for settlement procedures. My sense is it sort of helps them think about how they'll work on it. But I find it not as black and white as in their documentation. But as with everything with the federal government, you talk to the initial parties involved will be the interior attorneys and a team of local folks in the federal agencies, and then there will be a group out of Washington, D.C. that looks at it, and it goes through a congressional review, and so this kind of documents how that process works. So how do you get there from here? I think one of the most important things is something that Jay said. It's good to be organized and together, know your goals, have your claims done, be in a position to say, we've done our claims, we've done our part, we want to talk about not having priority calls, we may want to talk about no loss of ag lands. These are our main 3 goals. We know your goals, you hear them from the tribe, are going to be you want in-stream flows, you want water quality improvements, you want habitat restoration. How do we do those things with some projects? But we want to be in a position where we can really focus on shared interests and the additional water uses for tribes not coming out of the traditional uses in your community. I have a colleague who's worked in the Klamath Basin in Oregon for 40 years. He's now the executive director of the Klamath Water Users Association. It's really hard because they've had a settlement in the mid-2000s, and then Congress did not enact it because of bigger political reasons. And so then they went back to litigating. They have like 10 cases going all the time, and it's just really hard on the community. It's been a difficult place to be. And my partner, he's always saying, the only thing that can change the way things are going are really good relationships, building relationships with other parties, reminding your representatives of their obligations and their policies about trying to find solutions and settlements, and really demanding bipartisanship. I think the other thing I've heard from a lot of people is having that ultimate optimism that it's going to happen and continuing to push in that direction, being relentless. And I think that you find people doing that in leadership. I'm very certain that the Ag Water Board has that kind of direction. I work with folks on the board there, and they're really motivated to find solutions to this adjudication that may be helpful for your entire community and economies. That's what I got. So it's not a fast process, but there's a different way to approach it, and I'm hoping that you guys can find that.